The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. Please listen carefully as I do so. People versus Tashawn Burrows is submitted. Solomon M. versus Adelaide M. submitted. Rusey Holding versus Inner City Elevator submitted. 11th Street Associates versus the City of New York. For the appellant,
Ronald Rosenberg.
6-1. For the respondent,
Yes, Zach Shapiro for respondents.
6 minutes. Rubio versus New York Proton. For the appellant,
Scott Brody.
5-1. For the respondent,
Scott Singer.
5 minutes.
5.
People versus James Moore for the appellant,
Shayna Watrous.
3-1. For the respondent,
Jennifer Westfall.
3 minutes. Laborers Pension versus CVS Health for the appellant,
Yes, Jonathan Lupkin on behalf of CVS Health. And I'm going to ask that my colleague, Mr. Farina from Williams and Connolly, be admitted pro hoc for the purposes of argument.
Good afternoon, Your Honor. Steve Farina on behalf of appellants.
Good afternoon. The motion is granted, 6-1. For the respondent,
Jonathan Gardner from Labaton Sucharo.
6 minutes. Hawk Mountain versus Ram Capital Group for the appellant,
Yeah, Alan Diamond with Diamond McCarthy, Your Honor. Also have with me here today Michael Kimberly of the law firm McDermott, Will and Emery, who will be making the oral argument today.
Okay, I'll grant the motion, and I have to add all these pro hoc vice. You know we have thousands of excellent New York lawyers, just for future information. 6-1. For the respondent,
Good afternoon. This is Todd Beatty on behalf of respondents.
6 minutes. Muser versus Brooke for the appellant,
Yes, this is Rachel Schulman. I represent Dr. Adam Brook, cross petitioner.
5-1. For the respondent,
Carl Huth.
and so the parties are aware, Justice Scarpullo is recused and Justice Mazzarelli will be vouched in. In that case, will be called first. People versus James Richardson for the appellant,
Daniel Horowitz from Howell, Schuster, and Goldberg for the appellant.
6-2. For the respondent,
Jeannie Campbell Urban from People. Good afternoon.
good afternoon, 6 minutes. Great Ajax versus PCG Rio Holdings for the appellant,
Robert Spolzino for the appellant, Great Ajax, Your Honor.
and at 6-2. For the respondent,
Tim Salter, Blank Rome for the respondents.
6 minutes. Katerina versus New York City Department of Buildings for the appellant, Katerina versus New York City Department of Buildings. Appellant, is the respondent there?
Yes, Your Honor, Julie Steiner for the respondent.
Okay, let's wait a little longer then for the appellant, Mr. Sayer, I believe.
He was here earlier, so, all
Okay, maybe he's having a little trouble. I'll move on and I'll come back.
right, thank you.
Martinez versus Patel for the appellant, Martinez versus Patel for the appellant. Okay, I'll come back to that one as well. Board of Managers versus Porterhouse versus Del Shaw. Board of Managers Porterhouse versus Del Shaw.
Joseph V. Cambereri for the appellant and cross respondent.
5-1. For the respondent,
Robert Carbone for the respondent cross appellant.
and that's 5. I'll give you 5-1. You're a cross appellant. DeJesus versus BSD 80 Broad LLC for the appellant, DeJesus versus BSD 80 Broad LLC for the appellant. Okay, I'll come back. Well, actually, that's submitted. Empire LLC versus Sharapov is submitted. Papadopoulos versus MTA is submitted. Rudd Mechanical versus Metro is submitted. I'm going to recall now Katerina versus NYC Department of Buildings. Is Mr. Sayer there? Okay, Ms. Steiner, I heard you make your appearance before. 5 minutes, okay?
Yes, thank you
So
very
we
much.
know. Mhm. And then Martinez versus Patel. Is the respondent present?
Yeah, for the plaintiff respondent, Arnold DeJoseph.
For the defendant respondent, Susan Matola.
And we still haven't heard from, I think it's Mr. Russo, is that the appellant?
That is correct, Your Honor.
Okay. All right. We'll start the calendar call and hopefully, I'm sorry, I'll move along and hopefully he will show up. Okay. Counsel, please remember, as always, that we have your briefs, we have the records, we're fully familiar with the facts of your case, so please go directly to the most important points you wish to make. Also, as is customary, please don't speak when a justice is speaking. It's particularly important during our virtual sessions so that you can hear the questions that are being asked. And finally, keep your mics muted. Try to remember to unmute them at the appropriate time. Okay, thank you very much. The first case for argument is the case we are calling out of turn. It is in the matter of Howard Muser versus and Adam Brook versus Howard Muser, rather. Muser versus Brook.
Yes. Shall I proceed?
Just a minute. Just let me make sure. Is Justice Massarelli on?
I'm here, but it says that it won't let me turn on my camera. Is my camera on? Now it is.
Yes.
Okay.
Yes. Okay. So is Ms. Schulman and Mr. Huth, are you both present?
Carl Huth, yes.
And Ms. Schulman, you're the appellant?
Yes.
Okay. We can only hear you, at least I can only hear you faintly. I don't know if you can increase your volume.
Is this better?
Better, yes. Can all the justices hear?
Yes.
Yes,
Okay.
I can hear.
Okay. Why don't you begin?
May it please the court, my name is Rachel Schulman. I represent cross-petitioner appellant Dr. Adam Brook. This case involves gross violations of substantive and procedural law in the realm of mental hygiene with catastrophic results. Adam Brook was his...
Go ahead. Ms. Schulman, let me just ask you, the AIP in this case is deceased. Is that correct? She passed away?
Yes, Your Honor.
Yes, well, I'm very sorry. But doesn't that render these issues moot?
No, Your Honor, the issue is not moot because adverse findings were made against the cross-petitioner, Dr. Adam Brook, and those findings were erroneous and should be reversed by this court. Adam Brook is an aggrieved party per CPLR 5515. He also happens to be a representative of the estate. He's a co-executor. But leaving these findings on the record is severely prejudicial for him in any future proceedings where they could be used against him. This was a case where such egregious errors occurred.
Well, what future proceedings are we speaking about?
Well, for example, another estate type matter where he would be a fiduciary. In this case, he was a power of attorney. He was healthcare proxy, and both of those were voided by the court based on a wrongful trial below. And it is this court's in a position now to reverse that to protect Adam's future rights, and also in terms of the future proceedings in this case where there has been 10 different attorneys have put in fee applications in this case that amount to about $700,000 in fee applications, where there was just such egregious error by the court in appointing this guardian, and the subsequent fallout was catastrophic in terms of finances and also the AIP's quick demise based on bad decision making. And with the court's permission, I can go through some of these errors.
No, we've read the briefs. We have the information. I'm just wondering how the future fees and such, how this would affect that. It sounds like you're asking for us to give an advisory opinion.
No, Your Honor. What we're requesting is that the findings be vacated and the case be remanded to a new judge, which the First Department did in matter of Gordon on December 1st, 2020. The cross petitioner in that case was not given a chance to put in evidence at the guardianship hearing, and the First Department reversed and remanded to a new judge. And that was
Mr. Rowley, had the person passed away at that point in that case?
No, that was not a mootness case, but the other issue did not.
I don't even understand how we have jurisdiction in this case.
Because findings were made on the record adverse to Dr. Adam Brooke, and if those findings are not reversed, they stand. And those findings are prejudicial to his future endeavors, where he would be, for example, another person's healthcare proxy or power of attorney, or other types of proceedings where his breach of fiduciary duty finding will prejudice him.
But there is no more guardianship.
That
there
is
may
correct.
be an estate when and if a representative is appointed, but there is no more guardianship.
He's the co-executor. There's letters have been administered below, and so he's still he's going to be administering the estate. And a finding of these gross breaches of fiduciary duty about how a son cared for his mother, is devastating, and it's legally improper for him to have to bear the consequence of these adverse findings based on such egregious error below, where his constitutional rights, where his mother's constitutional rights were violated, and the MHL was not followed. There was just a complete lack of due process, and just such unfair proceedings where the AIP was not even in attendance at the key hearing date, although she had said she wanted to be. And Dr. Brooke had a recording
Ms.
of
Shulman,
her that.
this is Justice Kennedy, and I'm not sure that your recitation is accurate, because there were 3 hearing dates, and on the first 2, the AIP was present. And then on the 3rd date, her attorney waived her appearance because the day prior she was released from the hospital and had indicated to her attorney she did not want to appear. So is there any other alleged error? Because she was present. Counsel waived her appearance, and she indicated she did not want to appear for the final date. Any other alleged errors here, Ms. Shulman?
Unfortunately, yes, thank you, Your Honor. Unfortunately, your recitation has some errors that have been mispresented. The attorney for the AIP never spoke to the AIP. Rather, she spoke to a home health aide, and the home health aide said she's not coming today. She was in the process of getting dressed to go and couldn't do it. She had just been released from the hospital. Her son, Adam Brooke, made a recording of her at the apartment where they co-resided that morning. I have it right here, and I'm happy to play it for the court. It's part of the record, where he says, "Mom, do you want to go to the hearing?" And she says, "Absolutely." And with Your Honor's permission, I'll play it right now.
No, you don't need to, but because that's not necessary. The bottom line is that she was present on 2 occasions, and did not want to appear. So what's the other error,
Honor,
Ms. Schulman? Ms. Schulman, what's the other error? That's my next question to you.
2 quick errors. There were 4 days. 2 of them were pretrial, 2 of them were trial. The AIP appeared at 1 pretrial, and then for the trial, which had 2 days, she appeared at the first day of it. At that first day, she never said, "I don't want to come back." She said, "I want this over with. The words, I do not want to participate any further," never occurred. She said, "I don't want this."
We've gone over time. Thank you very much. Perhaps you could address the mootness on rebuttal. Mr. Huth?
Yes, may it please the court, Carl Huth for the respondent, Howard Muser. I will go straight to mootness. The only arguments that the petitioner asserts for getting beyond the clear law in this state that the death of the AIP voids and moots all issues relating to the selection and appointment of the guardian, which is set forth in the Zofia and Klassen cases, is an argument that he is nonetheless aggrieved because he does not like the finding that the court made that he had, among other things, breached his fiduciary duties that led to the voiding of the existing power of attorney and the healthcare proxy. To argue that he is aggrieved, petitioner has to look far beyond guardianship law, because there are no guardianship cases cited in this record in which a finding of an aggrieved party was found to eliminate the mootness caused by the intervening death of the AIP. He has to look to car crash cases, and he cites 2 of them, Lincoln versus Ostick and Mixon versus TBV. Those cases made it clear, and this is a quote from the Lincoln case, that in order for a party to be aggrieved such that he can appeal despite the mootness caused by the death of the action, in this case an automobile case, the interest that he seeks to protect that is aggrieved must be, quote, substantial and important. And in both the Lincoln case and in the Mixon case, we saw exactly what that means, a legal right that the person who is appealing has a right to pursue that is nonetheless destroyed or else significantly damaged by the finding in the case below. In Lincoln versus Ostick, there was a question that a jury had found in an automobile accident case. They found no liability, but they did find that there was authority given by the vehicle's owner for the driver who got involved in an injurious accident. That owner was at that moment a defendant in another case, and the collateral estoppel effect of that finding made him aggrieved. It prevented him from advocating for his own rights. In the Mixon versus TBV case, again, it was a multi-car accident case. The defendants in one of the vehicles had launched a contribution act against another vehicle, and the plaintiffs in a previous case against that other vehicle had failed to appeal an adverse decision, and the court found that because of the pending contribution action, there was a real, substantial, important interest that those van driver defendants had that would be impaired if the reasoning in the initial case was allowed to stand. That is what aggrieved means. It means a legal right that cannot be prosecuted because of this finding. There is no legal right that Adam Brook can contest on this case. He cannot have the power of attorney put back in place. The AIP has died. He cannot get the healthcare proxy back. The AIP has died. The fact that he breached his fiduciary duties in connection with his previous service on behalf of his mother, his mother has now passed away. There is no circumstance in which he can act as a fiduciary for her again. And the only argument that Dr. Brook has now put forward in this argument is that there may be in the future another estate type matter.
Excuse me, I just would like to ask you one question is, if the, you say there's been a breach of fiduciary duty by the appellant, how does he challenge that finding if he feels or if he firmly believes that that's inaccurate? How does he challenge that?
He has the right to, well, he had the right to do it before. At this point, that is.
Well, he had no control over the death, of when the AIP passed away. So how does he challenge that finding?
Well, he can't in an appeal from a decision appointing a guardian. because that's moot. This is the point of mootness. Mootness always leaves somebody with an
Well,
interest.
he has to have some remedy available if that finding needs to be challenged. What's his remedy?
Well, Your Honor, he has no legal interest that's been aggrieved, so he has not provided a remedy on that. He does have the right, and this is similar to the Mixon case. If he wants to modify a finding in the court below, the court continues to have jurisdiction. We're still in the fee phase.
The final accounting on the AIP's estate, not her death estate, but this final accounting here as an AIP. Couldn't he be surcharged for his breach of fiduciary duty?
Many things could happen. In fact, the fees have not yet been awarded, but that is not before this court. This was not an order awarding fees or a surcharge. And if that occurs,
you don't want to educate me on how he can be, how he can have a remedy.
He has a remedy in the court below, to the extent that he wants the court to revisit or modify a prior order. The court still has jurisdiction. He is at this moment continuing to prosecute fees, which is in the record. And that is, to be honest, the only actual interest I believe that he has put forward. The interest he has as an heir, which does not give him standing independently, and possibly in his own right as one for whom fees could be assessed against. Those fees have not yet been assessed. So if he has an interest that is aggrieved that he needs to appeal, that will be in a separate appeal, not this one.
But from this same proceeding, you're saying that this same proceeding is still extant in the Supreme Court?
That's correct. 3 appeals have actually been filed so far. This is the first one to come to argument, but the court has not yet entered an award of fees below.
Thank you.
Quickly on the point of standing.
Thank you, counsel. Any other questions from the panel? Thank you, counsel. Ms. Schulman, you have a minute.
Thank you. Yes, the problem is that this case lacks, Adam Brook lacks any kind of remedy if this court does not issue the vacator. He is intending to sue these defendants for procuring the guardianship by fraud. And certainly the findings below would be very prejudicial in that instance. And as far as substantial and important rights being violated on Adam's part, any future endeavors where he would seek to service another person's fiduciary, this could be used against him. He could be remarried. He could have a wife who wants to include him as a Harvard-educated, board-certified cardiothoracic surgeon as an excellent choice as one's healthcare proxy. However, that would be prejudiced severely by the findings below. And as far as fundamental fairness, if this case is remanded to the same judge who appointed a guardianship in violation of the MHL and in violation of a constitutional law, that's no place for this case to go back and say, oh, well, the judge could make new findings, because this just is the same judge who has already issued a determination on a rash basis. This case should be remanded to a new judge to handle the fee application.
Thank you. Thank you both.
Thank you.
Thank you.
Russi Holding versus Inner City Elevator. We just have to wait for Justice Scarpula to get back on if she's not already here. I'm sorry. I didn't mean Russo. Sorry. 11th Street Associates.
Good afternoon, Your Honor. My name
versus City of New York. Just a minute. Is Justice Scarpula back on?
I am.
Okay. Okay. Okay.
May I begin?
Yes.
Okay. Good afternoon, Your Honor. My name is Ronald J. Rosenberg. I have the distinct honor and pleasure of representing the appellant in this case. And this is an appeal from a breach of contract action in which the appellant has entered into an agreement with the city to give Ford housing to homeless people. And this is the third action this plaintiff had to bring to recover under the agreement, as the city doesn't voluntarily pay. The city did pay for the housing from 2007 until mid-2010.
Counsel, pursuant to the MOU, there were certain rules, certain agreements as to when payment would be made. And it was the individual, the resident, had to actually be present at the facility. There had to be certain signatures and the log and on all of this. Was that clear here? Is this the kind of account stated where there's no question about the sum of money?
Your Honor, with all due respect, that is not the way the contract reads. The contract reads that the condition proceeding to getting paid is the filing of the certification by the landlord that the tenant has been in possession, the occupant has been in possession for the period of time sought. And this issue was already decided by Justice Jaffe in a previous decision where the city raised a similar argument. The signing of
this is for a period of time, for example, where one of the individuals was in a hospital. I can't remember for what the period of time was, but these are the kinds of issues that are here.
Okay, well, let's just talk. That was Mr. Grayton, and he was only in the hospital from sometime in May or June of 2012 to August 7th, 2012. But the proof that he was it's still in occupancy is overwhelming. The city paid visits to him at this room on November 2011 and March and May of 2012. That's at the record 716, 718. They also have an affidavit from the decedent, before he died, obviously, in which he said, I have a quote, I have resided at the premises continually without interruption since approximately May 2007. That's at.
So let me ask him more direct. Doesn't the MOU's express language, the actual language in the MOU, and the plaintiff's own registration logs, your own registration logs, aren't they sufficient to defeat the motion for summary judgment here?
I'm not sure I understand. Defeat.
Well, there are no, I don't believe that there was a submission of any copies of all of the signed registration logs for the rooms that were occupied by.
Your Honor, actually, that's.
Yeah, please don't talk over me.
I apologize.
Yeah, by the people who are at issue here, the three individuals, and I believe it was required to do that under the MOU. The MOU states no payment is due without that.
Absolutely does not say that.
Oh, okay.
It does not say that at all. It says that if there's a gap in the signature logs, that would lead the city to assume that they weren't in possession. However, the city knew from actual direct knowledge because they visited it. And by the way, with Mr. Grayton, the facility signature logs are in record 156.
So it's your position that there are no gaps or inconsistencies in the logs that were submitted?
I'm saying that the logs are not a condition proceeding to being paid. And the fact of the matter is that the city was already told previously of the difficulty of having people sign logs. But the evidence that they knew that these people were in occupancy is overwhelming. They visited them there. We have their affidavits. Each one gave an affidavit that's not refuted, that says they've continually resided in the premises for the period in question. There's no one who said that is not true. And the logs are, could you give me the agreement? Only allowed, I'm sorry, Ron.
Okay.
Which is the section for? Payments. Oh, 7. Okay, on record on R70, it says on paragraph D, it says the operator will submit monthly billing requests to HRA's SRO billing unit that will include a cover letter on letterhead stationery indicating the numbers of clients served that month, the agreed upon per diem rate, the amount due for the month, and will attach a copy of the daily sign-in sheet. This will ensure that they'll be aware. In absence of a daily sign-in sheet, the HRA will assume that he left the premises. Where's the part?
72.
And then it says, and no payment is due for the client. Aren't there at least issues of fact here?
Absolutely not. Article 2, Section B says, on behalf of each referred eligible person placed at the facility during the term of the MOU, HRA shall pay the operator at a nightly rate of $70 for each eligible person occupying a room in the facility. HRA shall pay this rate from the first night the eligible person registers at the facility until the day the eligible person departs from the facility.
Okay, thank you. Any questions from the panel?
I just want to also say, and council, doesn't it also say that you only get paid for the number of nights the eligible person actually occupies the room?
There's no such.
You are seeking payment for a period of time, at least a couple of months, when someone was in the hospital, correct?
That's correct, but
So
I
that
don't
person
agree.
isn't actually occupying the room during the period of time that you are seeking payment, correct?
Honor, my understanding of the law, it's a matter of law. You're occupying the room if you have exclusive possession and the landlord has no control.
Actually occupying the room means something else.
I asked you not to speak over the justice, please.
All right. Actually occupying the room means a little bit more than occupying the room. Actually occupying the room is much a different term. But okay, so we have this disagreement. Thank you.
Well, we have this disagreement. We're going to be setting a precedent that someone
Counsel, your time is up. You can respond on rebuttal. Mr. Shapiro, please.
Yes, Zach Shapiro for respondents. May it please the court. Starting off with Justice Renwick's question.
Thank you, but
apologies.
Sorry.
The MOU expressly states that in the absence of registration logs or a proper explanation, there's no evidence of any such explanation here, no payment is due. And the provision that my colleague is pointing to about the timing of when HRA will pay doesn't negate that requirement of what needs to be submitted along with the invoice. And we just don't have that here. With respect to their point that their claim that the city had actual knowledge that they were continuing to reside there, there's voluminous evidence, there's affidavits, there's case records showing that each of these clients relocated to permanent housing elsewhere. Their case managers personally assisted them with moving. They visited them at those new housing, those new apartments. The fact that at some point the clients returned to the hotel without new HRA referrals, as would have been required by the MOU, and that after that point there were additional visits, doesn't say anything about whether the MOU is satisfied here.
What about client counsel's argument that this has been decided before? This has been granted already in the lower courts.
Well, they never argued collateral estoppel in their opening brief, so I think they waived that. But the case that they're pointing to, Brannick, is completely distinguishable, and Supreme Court explained as much at pages 17 to 18 of the record. And the major distinctions are that in that case, there was absolutely no disagreement that the clients there hadn't been relocated, and there was absolutely no disagreement that that 11th Street told HRA at the time that the clients are refusing to sign the logs, but they're still living here. We don't have that evidence in this case, and that's just, I mean, that's the alternative way of satisfying the MOU, provision 1D at the top of page 70 in the absence of logs. We don't have the logs here, and we don't have any admissible evidence that there was that contemporaneous explanation. So that case is just different on the facts.
Did you any questions from the panel? Did you have anything else? Your time is not up yet.
So just picking up with Justice Scarpullo's question, the MOU talks about actual occupancy, and my colleague's citation to cases from the landlord-tenant context are just have no relevance to this case. They pertain, if anything, to the relationship between 11th Street and the clients. They say nothing about whether the city as a non-tenant has an obligation to pay under the contractual terms of the MOU. So applying those cases here is just ignoring the express requirement of actual occupancy in the contract.
Thank you.
Thank you.
Thank you. Back to you, Mr. Rosenberg.
Okay, quickly, I want to say that we've won summary judgment 5 times with 4 different judges on these very same issues, but there's one issue that hasn't been addressed, which is the account stated. There was no opposition below on the account stated whatsoever. As a matter of law, we're entitled to a judgment on that. They were billed for 6 years without objection, and the judge below found that we didn't make a prima facie case when we gave an affidavit of submitting these invoices and copies of all the invoices. It's all in the record. And as a matter of law, any of the arguments they raise now are not even subject to review. So,
Counsel, this is Justice Kennedy. With respect to the account stated, how do you address the fact that defendants did send letters indicating that the clients were no longer residing at the hotel, and that was a prerequisite, and that they would not pay? They would not submit payment. They challenged the payment.
they subsequently paid and acknowledged the people were in possession. So, and this idea that you have to sleep there. So if someone rents a room out, if they put a homeless person in there and he goes away to visit his friends for a week, they don't have to pay for the room. That means the landlord is not getting paid for the room. You can't take back possession, self-help. So it can't be a reasonable construction that you have to show that the person physically slept in the room. What you have to show is they occupied and had exclusive occupancy of the room. There's no dispute in this record. They had it all the way through the time period we have. We have photographs.
Well, Mr. Rosenberg, the defendant did challenge payment. They said they were not going to pay.
They did not challenge payment, Your Honor. It's not in their opposition papers. Look at their opposition papers. Read
Counsel,
them.
yeah. Okay.
Read them as much as you want, and you won't find.
We are going to do just that. Thank you very much.
Thank you, Your Honor.
People versus James Moore. I'm sorry. I apologize. Rubio versus NY Proton. Mr. Brody.
Good afternoon, Your Honors. May it please the court. The central issue in this case revolves around whether or not the area where Mr. Rubio fell was an elevation-related risk. In addressing that, though, I just very briefly want to point out that with regards to appellant New York Proton Management, LLC, there's no evidence in this record as to their relationship to this project whatsoever. And so just on that ground, summary judgment against that entity should not be granted. And
well, if this is a 240 sub 1 and they're the owner, aren't they strictly liable here?
Well, there's nothing in the record to state that they're the owner. So if there's nothing to establish their ownership interest, no summary judgment can be granted against them. There's nothing in the record to establish that New York Proton Management, LLC is the owner of the premises.
Mr. Broder, this is Justice Kennedy. Did you raise that argument below? Because I believe it's unpreserved. Did you raise that argument below?
Your Honor, I believe that argument is preserved by the record. A review of the record will show that there's no evidence raised against.
No, that's not what I asked you. I asked you, did you raise that argument below? That's my question.
Prior counsel did not raise that argument below.
Okay, why don't you move on to the issue that you were addressing now that we know you didn't raise it?
Well,
the other issue.
The issue here, Your Honor, is there were an area where there was MEP piping going through the floor at this particular premises.
Where are the facts here? And from my understanding, my reading of this is that there's a sheet of plywood over a trench that's 3 feet deep. It's not secured. This gentleman is carrying a box of that has electrical cables in it. He's moving from one wall to a wall on the other side of the room, and he walks over the plywood and he falls in.
Well, the evidence would be that there's not a sheet of plywood. There's an entire run of plywood.
However much plywood there is, he fell into the ditch or the.
Well, it's not that's the problem. It's not a ditch.
Okay, call it what you like.
Okay,
it was 3 feet. May I call it what you like? It was 3 feet deep, and he ended up in it because the plywood moved, fell, whatever. He fell into the. How would you like to refer to it?
I'll adopt the term trench, but it's not an empty trench. It's an MEP trench. And the plywood
Counsel,
was
what difference
designed
does
to
it
move.
make, if I might, what difference does it make if it's an empty trench or a trench with gravel or a trench with cables or whatever? It's covered with something. He is walking over, the something is plywood. He's walking over it, it moves, he falls in.
Okay, and the reason I think it matters, Your Honors, is that these pieces of plywood that were installed were designed to move. They were flush to the floor with a small lip. This was an area that people needed to access.
There's a question, Counsel.
This is Judge Scarpula. Isn't it also true that the plywood was supposed to be secured and it wasn't?
No, if the plywood was secured.
Wasn't there testimony that from someone on the job that said that that should have been secured?
It should have been within the lips that were created
and
so
it
that
wasn't,
it sets into
correct?
a channel. They're not secured beyond being set into the channel because the workers need to access it.
Yes, I hear what you're saying, but could you listen to me for 1 second? And I just want to establish, we both agree that that piece of plywood wasn't secured the way that the plywood, other plywood had been secured, one, and it was much thinner, or at least 1/4 of an inch thinner than other plywood that has been covering up that trench, correct? Or other trenches?
I agree that it was thinner, but there's no evidence that the thinner mattered.
Okay, I have a question. Go ahead if you want to finish up.
Okay.
Did you have a question, Justice Carspula?
I didn't want to interrupt.
And it wasn't secured, right? It was not secured.
It was not secured other than by the lip.
However you want to say it, it wasn't secured. And that's what allowed it to pop up and allow the guy to fall in.
That's the plaintiff's testimony.
Well, let me ask you a question, Counsel. Was it there how were they supposed to be walking on it? Why was it there? Were they not supposed to walk on it?
I think it was there because people were going to walk on it.
Okay, so it was placed there with the full intention that the workers who needed to get around would be walking on it. And when one of the workers was walking on it, it moved in a way that caused him to fall into it. Is that right?
That is the testimony, yes.
Okay, all right.
The issue, though, is whether or not that was a tripping hazard or some other hazard, or was it an elevation-related hazard that one of the devices within the statute was designed to protect against?
Mr. Burley, this is Justice Kennedy, and I know that you said that, the plaintiff was not exposed to an elevated risk. But what about, our case law when we indicate that protections are required for reasonably prevented gravity-related accidents? And that's what we have here. There's plenty of case law that talks about a violation of the statute when workers fall through the unprotected floor openings. That's what we have here.
The only distinction that is made in those cases is they talk about a situation where those coverings are designed to protect you from falling to the floor below, such as in the Vitale case.
That's not true, Counsel. I was just on a case in 2020. That's just not so. That's just not so. We have several cases where there are what did you call this again? Whatever word you want to use for this. Let's move on. We're beyond time. Let's go to Mr. Singer.
Your Honors, I just want to comment. There's a case Cross against CIM that this court decided. One of the issues that appellant raised was that this was a passageway, and in Cross against CIM, the plaintiff fell through a decking sheet, unsupported decking sheet, and in a passageway. Unfortunately, it's not spelled out in the decision, but it's in the record if Your Honors are interested. Aside from that, I'll rest on my brief unless there are any questions from the court.
Let's go back to Mr. Brody. Thank you.
Thank you, Your Honor.
The only thing I'll state, Your Honors, is that I believe that this case is much more equivalent to cases such as Vitale versus Astoria Energy, where This was flushed to the ground. There was no device that the plaintiff would have been provided that would have prevented this accident
The
from happening.
device, counsel, is the very plywood he was walking on. Either it should have been thick enough, dry enough, or secured enough so that he didn't end up through it. It's not as if he had to have a harness which would suspend him from the ceiling. That's not what we're talking about, nor what we suggest, nor what is stated in the cases.
The only issue is that makes every flush service an elevation-related risk. Here, there was the need to access this area, which the plaintiff was fully aware of.
So let me just correct you. It's not elevation, it's gravity-related risk, right? That's what it is, a gravity-related risk, which is different from an elevated-related risk.
Well,
And both are covered by 240 subsection 1.
Well,
yeah.
What we're doing is we're making the floor a gravity-related risk, and that's the concern here.
Okay.
Okay, thank you.
Thank you.
Thank you both. People versus James Moore.
May I begin?
Yes.
Good afternoon. May it please the court, Shayna Watrous on behalf of Mr. Moore. So before I turn to Mr. Moore's declining health and sentence, I just wanted to note that the clear surveillance footage in this case did not show Mr. Moore intentionally use force against the complainant, and his robbery conviction is against the weight of the evidence. Mr. Moore—
Well, he didn't take his hands and stand there and push, with force, in that way, but there are different ways to use force. It doesn't have to be in that way. And if you're pushing, if you want to disable someone and you want them to fall to the floor, well, what Mr. Moore did in using his shoulder to push against the person when he either could have stood back or walked along the side, or there were a number of ways to get by him. And I understand his intent was to steal the wallet or steal whatever it was. So he had to get close enough to him in order to do that. But it was a prolonged sort of contact. Wouldn't that? Yeah, go ahead.
Right. So he wasn't trying to get by him, as you said. He was trying to put his hand into the bag that was on the other side of this man's body. He certainly made some contact because, Casper turned around, noticed him, clearly distracted. And if you watch in the video, if you look at his feet, the moment that he loses balance is not when Mr. Moore is reaching for the wallet, but rather when he reaches at the end of the conveyor belt at the bottom of the escalator, the raised metal lip there, and then he sort of falls, sort of slowly slides to the floor. But Mr. Moore was not intending to use force. And certainly you can, there are different ways to push people. I understand that. But here there is clearly, I believe, a reasonable view of the evidence that—
Wasn't there a jury trial here where the jurors, 12 of them, got a chance to see the video?
Yes, Your Honor.
And got a chance to hear counsel talk about how they wanted them to view the video? And so these people came up with a different reasonable conclusion.
They did. And, what we're considering here is not whether it was reasonable to convict him, but rather whether there was any reasonable view of the evidence that he did not commit the robbery. Certainly he was properly convicted of the grand larcenies in this case, but that's what the weight of the evidence review of this court is for. And, it can be confusing maybe for a jury to think, as long as he intended to steal the wallet, that that's enough. But really
the charge for force was given. I don't see anything in here about there are any issues with regard to the charge. So the charge about force was given.
Sure,
and I imagine the summation would have involved arguments and also the questioning that there was no force.
Right.
And still they found that there was.
They found that it was, but, this court is just as well positioned to view the video and make that consideration as the jury was. This isn't about, the demeanor of a witness that only the jury should be deferred to in that case. It's there in black and white. I would just encourage the court to take another look at the video, because it really doesn't make sense that he would have tried to call attention to himself, push this old man to the floor in the middle of Penn Station when he uses a cane himself. He can't get away quickly.
Well, that might be the very reason to push him to the floor, because he can't get away quickly. In any case, did you, we'll come back to you for, you have a minute rebuttal.
Thank you.
Ms. Westfall?
Good afternoon, and may it please the court, Jennifer Westfall for the people. The evidence at trial proved that defendant intentionally pushed an 88-year-old man down the last few steps of an escalator and stole his wallet from him in the process. The victim testified clearly and consistently that he had been pushed as he neared the bottom, and the surveillance footage fully corroborated his testimony. This evidence fully supported the jury's
And this
verdict.
gentleman also was in his 70s, wasn't he? It's not.
Yes, he's 75.
You made a point of saying the other gentleman was 88. So what counsel's saying is that this person, he wasn't planning to use force. He, I guess, could have used his cane or anything else. And usually force in this instance happens abruptly so that you can grab whatever you need and move off. What about the video where counsel is saying that it's not until he got to the bottom where the level changed that he fell? Why? Yeah. Is this against the weight?
I'm sorry. I don't think it's against the weight of the evidence. I think as the trial prosecutor aptly described it, it's a long continuous push down the last few steps of the escalator. In any case, the jury had the video. They had the testimony of the victim who said he felt pushed, and it wasn't a light brush. It wasn't grasping like Mr. Moore was falling or having a hard time balancing. It was a push, and he said that push caused him to fall. I think if you watch the video, the use of force happens up to and through the lip. So it's not like the defendant pushed him and then he, while unbalanced, tripped and fell over himself.
What about the excessive force? I'm sorry, excessive sentence. Sorry.
I would argue that defendant's sentence is fair and should not now be disturbed. COVID cases are still low at his prison. In fact, the numbers are largely unchanged from when I filed my brief. There have only been 2 more instances where an inmate has tested positive in over a month.
What about his advanced health? The several of the issues that he has that have been advancing.
I would just say
His
that
cancer, HIV, heart failure, COPD, these things don't stand still. What about those things?
I would just say that the trial court was fully aware of the defendant's health when he sentenced him. He did decline to make him a persistent felony offender. And I would also just point out that defendant's current applications for medical parole and his habeas petition urging release based on these health issue claims were both denied, with the latter being denied because of a lack of medical evidence.
Now, counsel, if I may, this is Justice Kennedy. Now, defendant has served, I believe, more than 3 years, right? And is close to release later this year. Is that correct?
I would need to double check. I'm not sure, Your Honor.
Now he was in a wheelchair as well, right? He's in a wheelchair?
Yes. I would just like to point out, though, in this court's case last year, People v. Eiffel, the defendant there was also in a wheelchair throughout trial and after he was sentenced, and his 25 to life sentence was upheld.
Of course, that's one factor, and there is a difference in the chart.
Of course.
Thank you very much. Thank you. Ms. Sorry.
Watrous, sorry.
Watrous, yes.
I just wanted to note, to follow up on the sentence point, Mr. Moore is not cannot do now what he could do 4 years ago. Mr. Moore's blindness has been escalating. Before, it was hard for him to see. He can no longer see. He cannot walk. He's in a wheelchair. He still has this late stage metastatic cancer. Sort of every day that he has now is a miracle. And he's incapacitated. To the extent that he may have been a threat before, he is no longer. Even at the time of sentencing, the Rikers doctors were very concerned about him and wanted him to be placed into a nursing home at that time. And he should be granted the dignity to die a free man in New York City, where his brother and sister can be near to him. And we ask that this court show mercy on him. He's given the questions about whether he actually intended to use force here, that had never been his MO in the past, and a history of grand larcenies he had committed, he's now incapacitated, and we would just ask that this court allow him to die a free man.
Thank you. Thank you both. Oh,
May I
I'm sorry.
ask
There's
one
another
question?
question. Sorry.
Sure.
Counsel for the People says that isn't corroborated. Do you agree with that? That his medical condition was not, that he's now incapacitated, has never been corroborated?
So, Your Honor, what the record that we're relying on here is that, the medical records, the extensive medical records that were presented to the court at sentencing, we obviously can't add to that. Counsel's referring to the very hasty habeas corpus petition that we had put together for Mr. Moore early in the pandemic. We hadn't had time to get his medical records. We have them now if this court would like them, but obviously we're confined to the record from sentencing.
No, I'm just trying to make sure that you feel confident that what you're representing is true, because clearly what penological advantage could there be to having somebody in his state still in prison, right?
He's not made
sure that we all agree that he is in that state.
He's not made a miraculous recovery, that's for sure. Thank you, Your Honor.
Thank you. Thank you both. Laborers Pension Fund.
May it please.
Versus CVS Health and Mr. Farina. You may begin.
May it please the court. Steve Farina on behalf of the appellants. I'm going to begin with a somewhat unusual request, but as we were on this call, we did receive a decision in a companion case that addressed literally these very same issues and these very same disclosures. The companion case is pending.
Well, let me just ask you first, did you share that with your opposing counsel?
We did.
Does he give you permission to make this application you're about to make?
I have not heard back from them. We sent the opinion to them 45 minutes ago. We received the opinion about an hour ago. I'm not going to argue the opinion. I don't think it's fair for me to argue it if the court doesn't have it and he hasn't had a chance to read it. We'd like leave of the court to submit it as supplemental authority. It is directly on point, raises all the same issues.
Is it from the companion federal case?
It is.
Okay.
And in fact, the complaint in that case is part of the record on appeal here at 309. Right. And it does address goodwill, Omnicare, and disclosures about customer losses. So we will submit that to the court. Thank you. The decision below here contravenes the express holding of the U.S. Supreme Court in Omnicare and therefore cannot stand. The lower court here found that defendants' goodwill opinions were potentially actionable because the complaint, quote, suggests that defendants likely did not believe the opinions expressed. And that is one of the narrow instances where an opinion can be actionable under the Omnicare standard. However, what the Supreme Court said in Omnicare is that if the plaintiff disclaims intentional misconduct, disclaims fraud or deception, they cannot avail themselves of this, what's called prong one of Omnicare. And that is exactly what the plaintiffs chose to do here. It was a strategic decision to—
So counsel, you're saying you can't have it both ways. You can't say no fraud, but fraud. You can't say no lie, but lie. It's either one or the other. And if you say that there is a lie, you've got to meet a heightened pleading standard. Is that what you're saying?
That is exactly what I'm saying, and that is exactly what's going on here. And that is a valid choice that the plaintiffs are allowed to make. But having made that choice, they have to live with the consequences. And one of them is that they do not have a, quote, prong one claim under Omnicare.
Let me just interrupt you, counsel. We all agree, and I think that both sides agree that this is an opinion. This is not a factual statement. So Omnicare, everyone agrees that Omnicare applies, correct?
Correct. And the opinion below also acknowledges that it is an opinion.
Right.
And we cited about a half dozen cases involving goodwill where the courts have all said that goodwill are opinions because the goodwill concept is dependent on valuation judgments that are subjective. So having specifically disclaimed fraud or any intentional conduct, and that's in the record on appeal at 302, it's repeated in every single one of the causes of action that the plaintiffs did not allege that defendants committed intentional or reckless misconduct. And they said this claim is based solely on negligence and or strict liability. And there is no allegation in the complaint that the defendants subjectively disbelieved the opinions that were being expressed. So even absent the express disclaimer, there's nothing in the complaint that actually alleges what the lower court found was a reasonable inference. So we don't think that, we think this is pretty cut and dried. The courts since Omnicare have applied that holding. We cited a couple of courts where just the same thing happened, where the plaintiff disavowed any intentional misconduct, and the court said, having done so, you might get the benefit of a lower pleading standard, but you do not have the ability to raise a prong one Omnicare claim. And that was the basis for the lower court's decision here. I think it's very clear from the opinion that that's what the court found. There are other ways in which an opinion can be actionable under the federal securities laws. They are narrow. They're intended to be narrow. We don't believe they're present here, and we don't believe that the court found that they were present here. And again, these issues are all addressed in the district court opinion that we will be submitting. But the second,
well, aren't they? You're talking about all of the three prongs of Omnicare right now, and the other two prongs. So I mean, it was pretty laid out in Omnicare itself.
Correct. And we feel that the complaint here, the judge, first of all, rested on prong one. We think that's unavailable. Prong two is really not even about actionable opinions. What prong two says, if in the course of expressing an opinion, you misstate a fact, so you literally make a misstatement of fact while you're making an opinion, that the fact that you've made an opinion doesn't protect the misstatement of fact. There is no misstatement of fact identified here. The plaintiffs are arguing.
Let me ask you this. What is your view of, well, you can imply that it's not so much a misstatement of fact as a failure to disclose facts that would inform the viewer, the reader, as to the validity of the opinion of goodwill. I mean, for example, you can say our goodwill is great, while at the same time you're being boycotted all over the country. So it would be a relevant fact to say, with respect to that opinion, we're being boycotted across the country, right?
Sure, Your Honor. Under the Omnicare standard, prong two addresses misstatements of fact. There are none here. Omissions.
I've moved on.
All right, moved on. Prong three
is where I'm at.
Prong three does relate to omissions, but it is a specific type of omission. It is an omission about how the opinion was formed. And again, I believe the decision is quite clear on that. And the Supreme Court in Omnicare made clear that simply the existence of some contrary fact is insufficient because opinions are assumed to rest on potentially competing facts. So the court in Omnicare said it is no small task to bring an omission claim based on an opinion. So the question here then is, were the disclosures, the opinion that was rendered, misleading as record? It is very detailed about the process that the company went through in arriving at its goodwill determination. And it specifically included the very things that the plaintiffs are arguing the company did not give adequate weight to in making its analysis, including—
Counsel, I've gone over time. If you would wrap up.
Yes, Your Honor. Your Honor, we think this is a clear-cut issue. It's a legal issue, and of simply applying Omnicare, and the many federal courts that have applied Omnicare, the case should be dismissed. Thank you.
Mr. Gardner, thank you.
Good afternoon, Your Honors. If it please the court, let me start with Mr. Frein is right. I haven't had a chance to read the federal court decision from Moradon, but I would just point a couple of things out. One, it was a claim under 10B of the 34 Act that has a heightened pleading standard under federal law. Overarching is the plausibility standard of Iqbal and Twombly, which is not present in New York State Court as a pleading standard. So the pleading standard in New York that Judge Maisley was applying is much lower than the pleading standard that the federal court was applying. And there's other differences. We had a former employee pled in our complaint that was not present in the federal action. So there's distinctions there that kind of render that decision, I think, not persuasive in this case. As far as the goodwill statement, I just want to point out quickly that the goodwill statements in the case, that's just one category of false statements. There are others, two other categories of false statements in the briefing. Goodwill is the only one that raises an opinion. I agree, goodwill is an opinion statement, but that is the only opinion statement issue in this case. As far as Omnicare holding is concerned, I think Mr. Farina overstates it when he says that Omnicare has held that a disclaimer in every case, in every circumstance, is a waiver of the first prong of Omnicare. In fact,
No. I don't think that's what he said. I think what he said is you can't have it both ways. You either have to say that there is a subjective belief that the statement is false, which is not negligence and not what you've pled, or you have to plead facts that show that. So that's what he's saying, and that's what Omnicare says. It's really not controversial at all. You cannot do both. You have to go one way or the other.
Well, I still think MF Global, the Southern District case, and Barclays, the Second Circuit case, is good law, and those cases say
those are before Omnicare, right?
That is correct, but I don't.
So that's Omnicare made it clear, and we go in that regard by the Supreme Court. Let me ask you this: assuming that we disagree that you cannot plead, that you can plead mere negligence and still have a good claim under prong one, have you met? What have you said about that? I mean, you'd have to amend, maybe you could amend your complaint to take out all those declarations, but would you be able to amend your complaint to actually allege subjective knowledge of falsity?
Well, I think we have alleged subjective falsity, and we've alleged
facts. You can't say that it's not and say that you have. So,
I'm sorry, Your Honor.
All right. Let me ask you. Yes. Okay. Tell me what you've alleged that you think would meet that standard.
So I understand we have a disagreement on Omnicare. I'm moving past that to
right. Me too.
And so what we pled are facts that show that the information that they had at the time of the registration statement was not incorporated into and not disclosed to the market. So what do they have? They didn't disclose that the goodwill testing was stale. The goodwill testing was done in the third quarter of 2017. That was right around the time that Rocky Kraft, Omnicare's president, left, which a former employee who was there at the time said that started a free fall, an exodus of vice presidents. It became very prevalent that Omnicare's business was declining following Kraft's departure. Omnicare was losing clients. They had significant losses of 10 to 25% of its customers. Omnicare had not won any new long-term care business or secured renewal of long-term care business because Omnicare customers did not want to work with CVS. So all of those facts underlying their statements, both the goodwill statements and the non-opinion statements we plead, are contrary to those facts. They didn't disclose that their accounts receivable were significantly inflated by millions of dollars.
So wait a second, counsel. Judge Maisley didn't treat this as anything else but an opinion case, correct?
Well, I think that she certainly spent most of her time.
No, show me. Is there anything in her opinion that would say that she treated it any other way?
Well, I don't have it directly in front of me, but I believe all of the facts that make the opinion statement misleading are the same facts that make the other statements misleading. So I think it's subsumed within her opinion, but in any event,
So you think you think that you pled it both ways?
We definitely pled that the goodwill accounting statements were misleading, that it was misleading to not tell the market that it was based upon a stale analysis, that there should have been an interim goodwill accounting impairment test done. And
would that have connected to anything else but the goodwill?
no, I was getting to the second point, which is there are several risk factors that we alleged, and I can bring it to the complaint paragraphs of the complaint and I'll put it in the record.
I'm going to just ask that you get there quickly because your time is up.
I just want to know because I didn't see Judge Maisley deal with any of that. I mean, she treated this as in a goodwill opinion case, and I didn't see her discuss any of the rest of what you're talking about now.
Well, it's in the complaint. It's why the complaint should be sustained. And I'm just saying, record 295 is where we have our second category of false statements relating to potential loss of customers and inability to win business. Record 296 in our complaint is category 4, where we talk about statements concerning integration and success of prior CVS acquisitions. And record 295 is our third category of false statements regarding the solvency of customers. All of those facts that I ticked off, and there are more, go to the falsity of those. And the other thing I would just leave you with is that in less than a year, in just about 1 year, CVS wrote off $6.14 billion of goodwill. 6.14 billion. 59% of that, 3.9 billion, they wrote off within the first 6 months after this acquisition. $6 billion of goodwill doesn't disappear in 1 year. And they've also admitted, we have this in our brief, they admitted at the end when new management came in and reran their impairment analysis and understood that they needed to take this huge, massive write-down, that they acknowledged that the facts underlying those write-downs were known to the company for years. They were the same issues that existed for years.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Farina, you have 1 minute.
Yes, very briefly. It is true that the district court case, the federal court case, is a 10b-5 case, but the court ruled that the statements that were not actionable under Omnicare. So the court did not even reach the scienter issue, which is the difference between the 10b-5 claim and the claim here. The only thing I would add is that we cited to the lower court 5 different cases involving goodwill write-offs. They're all essentially identical to this one. Something bad happens. The plaintiffs say, you knew it sooner. You should have written goodwill off sooner. The overwhelming weight of authority, including the case that was just decided today, says that's not enough. And the court didn't address any of those cases. And we think that the overwhelming authority supports dismissal here as well.
Your Honor, can I have 10 seconds to respond to that?
No, thank you.
Thank you.
Thank you both. Hawk Mountain versus Ram Capital Group.
Good morning, Your Honor. May it please the court, Michael Kimberly for Appellant Hawk Mountain. Your Honors, the question whether the trial court erred in dismissing this case turns on 2 issues that share some overlapping themes. The first is whether the action is barred by the statute of limitations, and the second is whether it's barred alternatively by the general mutual release. And our position is that it's barred by neither and that the court should reverse. I'll start briefly with the statute of limitations and then transition to the release issue. So as a starting point, Ram Capital agrees with us on appeal that the trial court erred when it concluded that January 31, 2014 comes after March 12, 2014 on the calendar. That appears on page 6 of the trial court's opinion. It's a straightforward mistake that not even Ram is defending on appeal, and so we won't dwell on it. What that means as a practical matter is that the only remaining question concerning the statute of limitations is the applicability of General Obligations Law 17-101, which is the statute that resets the SOL when a debt is acknowledged. So the question on this score is whether the SDA recognized the existing debt from Hawk to Ram and at the same time did nothing inconsistent with an intent to pay that debt. And to understand application of those principles here, you just have to look at the plain language of the SDA, which I think speaks for itself. The key language appears at R258. This is the plan of distribution. It's annexed and incorporated by Section 3 of the SDA. And it specifies that RAM Capital, which is controlled by Mira, quote, agrees to make full payment and satisfaction all of the outstanding indebtedness plus accrued interest, which RAM Capital Group LLC owes to Hawk Mountain LLC. And then in attached schedules to the plan of distribution, it shows that RAM Capital at the time of the signing owed some $8.1 million in combined principal and interest to Hawk Mountain. In our view, an acknowledgement under 17-101 doesn't get a whole lot more clear than that.
Counsel, this is Judge Scarpullo. What do you say to the trial court's finding that the numbers weren't exactly the same, and therefore it wasn't, that couldn't have been an acknowledgement of the debt under the note? What do you have to say about that?
Well, Your Honor, what the plan of distribution acknowledges is all of the outstanding indebtedness. The complaint does not allege that the 2005 note comprises all of the outstanding indebtedness. It alleges an amount that is less than what is scheduled. And so our position, I think, confirmed by cases like Faulkner against Arista Records, which says that the acknowledgement of a precise amount isn't necessary, is that there really isn't any ambiguity, that there's an allegation that this amount is owed on the note. There is a statement from RAM that it intends to pay all outstanding indebtedness, and this amount is subsumed within the amount scheduled.
So recognizing an existing debt is sufficient, is what you're saying?
Well, I wouldn't say just any debt. I think what's key
right,
here
not
is
any
that,
debt, and meaning the specific and existing debt, a specific debt, as in lieu.
Correct, Your Honor. And I think the plan of distribution accomplishes that by saying all outstanding debt.
And there is reference to a note, right?
That is correct, Your Honor. That's correct, Your Honor. And certainly to the extent there's any uncertainty about this, our position, especially as the non-moving parties here, is that that uncertainty has to be resolved in Hawk's favor. If there's a factual question whether, in fact, the 2005 note is subsumed by this acknowledgement, that's an issue that we can address in later discovery.
Okay, what do you say, counsel? This is Judge Scarpullo. What do you say about the release? Why isn't this debt released under the release?
Well, I guess I'll start with the first point, which the release comprises two parts. It's the main body of the release, which is the general release, and then a final sentence, which is a carve out on that general release. We don't dispute that the note falls within the terms of the main body of the release. The only question here is whether RAM's debt to Hawk falls within the carve out. I guess I'll pause here briefly just to note that my friend on the other side says, I think somewhat misleadingly on page 15 of his brief, that the trial court found that our argument on this point was barred by collateral estoppel. And that's in fact not true, because the trial court found that our challenge to the validity of the release was collaterally estopped. And that is not a point that we dispute on appeal. It then, on the final page of its opinion, expressly refused to apply collateral estoppel to the question whether the carve out applied. And that's the only issue presented here before this court. So setting aside collateral estoppel, the carve out, and this is at R261, says, and I'll quote, it's very brief, Jordan is not releasing hereby Mira from claims that arise under the express terms and conditions of, and specified in, among other things, the distribution agreement. And of course, it is the distribution agreement that says that Mira agrees to make full payment and satisfaction all of the outstanding indebtedness that RAM then owed Hawk. So I think it's a very straightforward interpretation of this carve out that the acknowledgement of debt in the plan of distribution has to be within the carve out. And indeed, if it weren't, it would render the agreement here self-contradictory. At the same time that the plan of distribution is acknowledging the debt, the release would be releasing liability on the debt. And that really doesn't make sense, we don't think, as just a plain language issue. And we think the best reading of the word Jordan in the carve out is simply as a reference back to Jordan making an agreement for or on behalf of her, among other things, affiliates.
Let's hear from Mr. Beatty now. I've given you your time.
Thank you, Your Honor.
Yes.
Thank you, Your Honors, and may it please the court. This is Todd Beatty on behalf of the respondent. I'd like to begin with the release and the plain meaning of the carve-out. The carve-out is expressed in terms of Jordan and Mira, no one else. By the plain meaning of Jordan and Mira, they refer to the individuals Jordan and Mira. If you look at the first sentence of the release, the operative release language, you see references to the defined terms Jordan releasing parties and Mira released parties. If Jordan and Mira had wanted the carve-out to extend beyond themselves, they could have used those defined terms. They didn't, and the court has to give effect to that choice. So we think that this issue can be disposed of just on the basis of the plain meaning. I would also note that the claim that's carved out has to arise under the express terms and conditions of and specified in the SDA. Their complaint doesn't even mention the SDA, much as any term. This cannot possibly be considered a claim arising under the SDA. On top of that, appellant's argument ignores the structure of the agreement, which is essentially an effort to settle the total amount of debt that was owed by Ram Capital to Hawk Mountain, debt that was tied to a number of different promissory notes, debt that was tied to a number of different efforts to draw on the line of credit on those promissory notes. The structure of the agreement is such that any prior promissory notes are effectively extinguished. And this is from section 10.1 of the SDA, which states that any prior written agreements having anything to do with the subject matter of the SDA are superseded by the terms of the SDA itself. So Jordan's option here was to sue Mira for breach of the SDA. She chose not to do that. And so we think the claims are straightforwardly barred by the release and the structure of the SDA itself. I would also point to the 7 Investments case, which is directly on point. That case also involved a carve-out provision, which was very similar to the one at issue here. The court decided in 7 Investments.
This is Judge Scarpullo. That carve-out was not even close to similar. I went back and looked at that case. That carve-out specifically said everything is gone and the only thing that's left is this agreement, which this could have said, but didn't say. It said something else in this case. So it's not really close to that case at all. And I want you to address why couldn't an equally reasonable view of the release is that everything here is here, but we are not releasing the underlying obligations, right? Because the statement in the release says we are not releasing the things that are in this agreement. So I can't imagine that one would just release $7 million worth of debt in the hope that an individual could pay it back in case they couldn't. Does that make sense to you?
No, so the structure of the agreement is that there's a representation about the total amount of debt that Ram Capital owes to Hawk Mountain. That's in Schedule 2.1.2. And what that says, that total is something like $7 million worth of principal plus $1 million of interest. So to the extent that there were obligations under the 2005 note, the one that's at issue here at the time of the SDA, those would have been funneled into that representation and warranty. Now, if Jordan felt that there were amounts that were not included that should have been represented and warranted, she could have sued Mira for breaching the representation and warranty in 2.1.2. She chose not to do that. She also could have sued Mr. Mira.
No. But what I'm saying to you is something different. It has nothing to do with the representation. You're telling me that in this agreement, she released the corporation from the debt and could only hold the individual responsible. And that's what I'm saying to you doesn't make any sense whatsoever to me.
Well, there's an express representation in the SDA itself where Mr. Mira states that he will be personally liable for any of the obligations under the agreement, including. Right.
That's exactly what I'm saying, is that why would you release the corporation in the most times you're trying to get the deep pocket in, not release the deep pocket, right?
The idea was that Mira and Jordan as well did not want there to be any lingering liabilities that would extend to their employees and their businesses. They wanted the liabilities to extend only to themselves personally. That's the structure of the agreement, and that's what it was designed to effectuate.
Okay.
With that, I think I would like to move on to the statute of limitations. Justice Scarpella had asked the question whether there's a specific reference in the SDA to the 2005 note. Emphatically, the answer to that is no. There is no reference whatsoever to the 2005 note. There's only a reference to the sum total of debt that was owed by Ram Capital to Hawk Mountain. Now, we think that the Zinn versus Stam case is directly on point. What that case says, it's a First Department case, is that when you have a number of different instances of indebtedness between two parties, that a general acknowledgement is not sufficient to restart the statute of limitations on all of them. And that's precisely what you have here. You have 9 different cases of drawing down on the line of credit. You have a number of different promissory notes.
Doesn't Zinn refer to general indebtedness, not particular claim?
That's precisely right. I think the acknowledgement was something to the effect of, I will pay you back on what I owe you. That's essentially a less formal way of saying what was done in the SDA, that there is a general indebtedness on a number of different notes, a number of different drawing downs on the line of credit.
But don't they seek to recover one debt here, not general indebtedness?
It's a general indebtedness that had accrued over a number of years. And the fact is that every time that Ram drew on the line of credit, there was a statute of each of those, because each one is a separate indebtedness with its own statute of limitations. And that's why Zinn says an acknowledgement can't be general. It has to at least give some way of identifying the specific debt that is being acknowledged and is the statute of limitations is being restarted on. So we think that that controls the question of whether the SDA restarted the statute of limitations. I would also note that there's a signature requirement under the statute.
And if you could wrap up, I've given you.
Counsel, this is Judge Scarpula. Wasn't there a schedule to the agreement? And in the schedule, doesn't it say note from Ram to Hawk Mountain?
It does not. So this is on the record at page 255.
Well, what does the schedule say, right? It says note, right?
It does not. It says lender, borrower. Lender is listed as Hawk Mountain. Borrower is listed as Ram Capital. There's one line item for principal and one line item for interest. And there's a misalignment between the amount that was owed on the 2005.
No, but there's the word note is in the agreement. And is it not?
With respect, it is not. You will not find the word note.
Okay.
Yeah.
Oh, okay.
If you could wrap up, counsel.
Yes,
just 30 seconds.
Just one final point is that there is no dispute that Mr. Mira signed the SDA in his personal capacity and not on behalf of his company. And in order to restart the statute of limitations, it would have to be the debtor, namely Ram Capital, signing the SDA, which it did not, and there's no dispute on that.
Thank you. Mr. Kimball, you have 1 minute.
Thank you, Your Honor. I'll take it in reverse order, starting with release. What I would note, Your Honor, is that my friend on the other side, his interpretation of the plan of distribution and its incorporation into the SDA is effectively to turn it into an assignment of Hawk Mountain's debt to Mira. And I would say if that's really what the parties intended, this is a very strange way to go about it. It's also inconsistent, I'll note, with the general ledger of Ram Capital, which is in the record at 480 to 81. This is the general ledger from 2009 after the SDA was signed, which continues to have the note debt from Ram to Hawk on Ram's books. So the idea that what was really going on here was the parties shifting these liabilities from the LLCs to the individuals really doesn't stand up. It doesn't make sense. And I would say also, even if it were a plausible interpretation of the agreement, it would be a basis for dismissal without prejudice. We can fix this error to the extent it's an error. I don't think it is, because I don't think it's a plausible interpretation. One brief final point on Zinn. Zinn is about multiple debts, and one couldn't tell whether the acknowledgement covered any particular debt. Again, here, the plan of distribution says all debts. That included the 2005 note. It logically could not have excluded it, and therefore is sufficient for 17-101.
Thank you. Thank you both, gentlemen.
Thank you, Your Honor.
People versus James Richardson.
Your Honors, this is Daniel Horowitz from Howell, Schuster, and Goldberg in conjunction with the Office of the Appellate Defender for Defendant Richardson. The prosecution was not ready when it filed its certificate of readiness on December 17th, 2012, its first certificate nearly 2 years after the indictment, because when it filed, it did not know the whereabouts of Isaac Coleman, the complainant and the only eyewitness to testify at trial. Prior to filing the certificate, the prosecution stated it was not ready and asked for adjournments 5 different times because Coleman was unavailable. And Coleman remained unavailable when the prosecution filed the certificate. And it's no mystery why the prosecution would file a certificate on December 17th despite being not ready. Simply, if they did not file one, the speedy trial clock would have expired on January 3rd, 11 days before the next court date. Now, that the prosecution needed Coleman to go to trial is easily discernible from the record, because the prosecution admitted as much and even represented that to the court. In their February 10th, 2013 motion, the prosecution moved the trial court to reconsider part of a prior 30-30 decision it made. It asked the court to order those 5 adjournments excluded because the adjournments were due to Coleman's absence. But as the DA admits to the court, if the prosecution could have gone to trial without Coleman, they couldn't have asked for that time to be excluded. Yet the prosecution argued that the adjournments following August 13th, September 5th, September 27th, October 22nd, and December 5th, and this is a quote, that, quote, on each of these adjournments, the people answered not ready because of their inability to secure the attendance at trial of the complainant. And when it filed its certificate of readiness, that was still true, yet somehow the prosecution was ready. The only thing to have changed was that the speedy trial clock would have expired. And then the record provides further evidence that the prosecution was not ready when it filed its certificate. That December 17th certificate bought the prosecution some time, but come January 14th, the prosecution had a choice. They either had to go to trial without Coleman or answer not ready, which would have resulted in the indictment being dismissed. Rather than do either of those things, they filed a Sirwa motion. Now, the motion was based on evidence that was 2 years old. So the key point here is that the Sirwa motion shows that the timing shows that the prosecution was simply not ready without Coleman. The calls at issue were 2 years old by the time the prosecution brought them to the court's attention. If the prosecution actually had a concern that Mr. Richardson was the cause of Coleman's absence, they would have brought these calls up at any of the past 5 adjournments at which they declared not ready for that very reason. They could not even establish the prima facie basis of the Sirwa motion that they were pushing forward. They had zero evidence that any so-called threat was actually communicated to Coleman, yet they had to prove that by clear and convincing evidence. They had none. The prosecution also had no evidence that they had even attempted to contact Coleman for at least 18 months after his grand jury testimony. So the clear takeaway from that is that the purpose of the Sirwa motion wasn't to win the motion, but simply to buy time. But this time, the bid for time paid off because they found Coleman. And as soon as Coleman was found, the prosecution withdrew the motion. And in doing so, they admitted to the court, and this is another quote, that the prosecution cannot satisfactorily demonstrate at this time that the complainant's unavailability has been caused by the threats made by defendant Richardson. But the prosecution's inability to prove the Sirwa motion wasn't limited to at that time. Nothing had changed from when they filed the motion. They couldn't prove it when they filed, and they couldn't prove it when they withdrew the motion. Simply, it was a motion to buy time. So all the court needs to find is that the prosecution was not ready on December 17th to find that the speedy trial clock would have expired on January 3rd. Now, my friend on the other side is likely to come up after me and say, well, there's an easy explanation for all of this. The people were ready with respect to Mr. Richardson, but not his co-defendant. But the court should not entertain this rewriting of the record. There is simply no indication in the record below that the prosecution had any intention of trying Mr. Richardson and his co-defendant separately. At each of those 5 calendar calls, when the prosecution answered not ready because Coleman was absent, they never distinguished between Mr. Richardson and his co-defendant. And the DA's story on appeal also contradicts what the prosecution represented to the trial court below. that reconsideration motion to have excluded those 5 adjournments was specific to Mr. Richardson. In other words, the prosecution said you should exclude that time because we were not ready as to Mr. Richardson because Coleman was not available. So to argue now that this was all explained by some secret intention of the prosecution to try the defendant separately plainly ignores the record and the prosecution's actions and the representations they made to the court below. So unless the panel has any questions for me, I will wait for rebuttal.
Okay.
Good afternoon, Your Honors. Jean Fullerman for the people. Can you hear me?
A little bit better at the end of your statement, not at the beginning.
Okay, I'll try to project.
That's better.
Okay. Your Honors, the court below was correct to find that the people's statement of readiness on December 17th was valid and not illusory. The record amply supports that determination by the court below. It is true, as counsel mentioned, that we wanted to have Isaac Coleman, the complaining witness, testify at the joint trial of Mr. McGregor and Mr. Richardson. And that is why we requested adjournments in Mr. Richardson's case earlier on in 2012, because we did hope to locate him and have him testify. We were entitled to do that, even if we didn't need him to testify in terms of being able to meet all of the elements of the crimes without the victim's testimony. By the time December of 2012 rolled around, we simply had to acknowledge the reality that too much time had gone by and we had to change our tactic with respect to how we were going to try the defendant. And that is why we filed the certificate of readiness on December 17th, having chosen in Mr. Richardson's case only that we would proceed without the complaining witness. We did not file a certificate of readiness in the co-defendant's case. I think that's crucial. And when counsel says that there's nothing to support the idea that we were planning to try the defendant alone without the victim, I would point you to the difference between the certificate of readiness that we did file in the defendant's case and the fact that we did not file one in Mr. McGregor's case. That is proof that we believed that we would be able to proceed to trial without Mr. Coleman with respect to Mr. Richardson's case, but did not think that we could do that with Mr. McGregor, which is why we didn't answer ready in Mr. McGregor's case on that day. I would also point you to the trial record as further support for our contention, which again, the court below agreed with, that we would have been able to put on a case against Mr. Richardson, the defendant, without Isaac Coleman's testimony. There was video surveillance that put both Mr. Coleman, the victim, and Mr. Richardson, the defendant, in the Manhattanville houses on the day of the shooting. There are medical records that establish that Mr. Coleman was shot that day. He went to St. Barnabas Hospital afterwards. And crucially, the defendant spoke with his sisters about his encounter with the victim after he was incarcerated and recorded Department of Corrections calls. He told his sisters that he acted on principle and that the victim got what he deserved. And in response to one of his sisters' remarks that he didn't quote, have to shoot the victim, the defendant said that he did wild out, but you know how my temper is. That's pretty strong evidence of the defendant's intent to commit assault against Mr. Coleman that didn't require Mr. Coleman's testimony. So I just detail that for you as a way of backing up our contention, which we made below and make again, that we were able to proceed to trial on Mr. Richardson's case, even if we didn't locate Mr. Coleman. I want to also address what counsel raised about the January 14th, 2013 Sirois application. Our Sirois application was an assertion that we didn't have the victim and therefore wanted to use his out-of-court statements at the defendant's trial. The idea that we filed that motion just to buy more time to look for the victim, I think is totally counterintuitive to just what everybody here knows a Sirois application is. It's clearly demonstrates our intent to move forward in Mr. Richardson's case without Mr. Coleman. And I would point the court to the fact that the defendant's repeated threats and instructions to his family members to get the victim to not cooperate in our case came on the heels of the victim's grand jury testimony, which was the last time the people had contact with the victim. If you look at that timing, we clearly had a good faith basis, not only to be concerned for the victim's safety in this case, but to conclude that the defendant's efforts to get the victim not to cooperate had succeeded, and therefore that we would be able to prevail at a Sirwa motion. Of course, March of 2013 rolls around, and we located Mr. Coleman, and as Mr. Coleman testified at trial, he was not willing to admit that his family had intimidated him into not cooperating. And so, of course, at that point, we withdraw the Sirwa application, because not only is Coleman available to us, therefore able to testify, but we can't establish that the defendant's threats didn't cause his, that we can't establish that the defendant's threats caused his unavailability if Coleman is telling us otherwise. But that doesn't mean that we didn't have a good faith basis for filing that motion in January of 2013 when we hadn't been able to get in touch with Coleman. Unless the court has other questions, I will respectfully request that you affirm, and I will rest on my brief. Thank you.
Mr. Horowitz?
Yes. So I'd like to address a few points. So first, the fact that they did not file a certificate of readiness with respect to Mr. Richardson's co-defendant is not really probative of anything. The fact that they were not ready without Coleman with respect to Mr. Richardson is the important point. And they admitted as such after the certificate of readiness when they filed that reconsideration motion and said, we could not go forward with respect to Mr. Richardson, not his co-defendant, with respect to Mr. Richardson without Coleman. So that's what they said after the certificate of readiness. That's really all the court needs to know about that. With respect to the supposed admission, Mr. Richardson did not admit on those phone calls to committing the crimes. All he did, what you can take away from those calls is that he did admit, yes, to shooting Coleman, but nothing in those calls would allow for the prosecution to eliminate a defense or accident theory from the case. So there's no way that the evidence that they had would have allowed for a conviction of the crimes charge. And if you think about what that—
You don't think the statement he makes is damning in this instance?
It wouldn't have supported a conviction of the crimes charge, because what he did not sign a confession that allowed—
He's talking to his sister, a relative, where one would think he was being forthright.
Absolutely, but what those calls support is that Mr. Richardson shot Coleman, but those calls are consistent with the idea that it was done either in self-defense, and Mr. Coleman admitted to attacking Mr. Richardson first, or done inadvertently as part of a struggle for the gun. And without Coleman's testimony, what the jury would have heard is not very much at all. All they would have had was this phone call played to them without any context. The jury would not have heard that Mr. Richardson brought the gun to the fight, but they would have heard that Coleman did. They would not have heard that Mr. Richardson stepped back to shoot him, or they would not have heard why either of them were—
This is Justice Kennedy. I don't recall that there being any evidence that defendant knew that Coleman had a gun or that he pulled the gun first, and certainly no evidence that Coleman was the initial aggressor.
Well, so Coleman testified that he charged at Richardson. So Coleman testified to being the initial aggressor. And then the testimony that Coleman had the gun was Devine Roseborough's testimony. She was a defense witness called by the co-defendant. She testified that Coleman came to her apartment afterwards and testified that Coleman had the gun. So
I understand, but the evidence that defendant knew that's what I'm referring to.
Well, so I guess the point is, without Coleman's testimony, the jury wouldn't have known anything. So the calls that Mr. Richardson placed to his sister provide no context whatsoever, and they would not have allowed the prosecution to convict Mr. Richardson of the crimes they were charged. And that's why 5 times before they filed the certificate, at the 5 immediately preceding calendar calls, the prosecution said, we're not ready. We don't have our witness.
Well, what about the calls that he made to his sister suggesting that, Coleman be threatened, and then after that, Coleman is unavailable, and that was after the grand jury testimony. So what about those calls suggesting that, threats should be made to Coleman? What about that as the people raised?
So that's relevant to whether the Sirois motion was made in good faith.
Exactly.
Exactly. So those calls, the prosecution had zero evidence that anything that Mr. Richardson said to his sister was ever communicated to Coleman, something they had to show by clear and convincing evidence. And those calls were made 2 years before they ever were brought to the court's attention. So if the prosecution actually thought that those calls were the reason that Coleman was unavailable, wouldn't they have said at those 5 preceding calendar calls, Judge, we don't have our witness and it's the defendant's fault? No, they didn't do that. They waited till after they filed the certificate of readiness, and they waited till after the speedy trial clock was about to expire. That's when they made their motion. They sat on those calls.
Thank you.
Thank you. Thank you.
Thank you. Thank you both. Great Ajax versus PCG Rio Holdings.
Good afternoon, Your Honors. May it please the court. My name is Robert Spalzino, and I represent the plaintiff appellant Great Ajax Operating Partnership. There are 3 reasons here why the Supreme Court's order granting summary judgment to the defendant should be reversed. The first is that the defendant never made out its prima facie entitlement to judgment as a matter of law in the first place. The only factual evidence, the only evidence the defendant submitted in support of its motion for summary judgment was several unsigned, unsworn transcripts. They didn't make up that deficiency ever with all of them, and with a few of them, they put in the 3116, CPLR 3116 evidence on reply. You can't make that out. You can't make out your case for summary judgment on reply. I know there's a second department case that says you can. I have great respect for the decisions of the second department. There was a time when I wrote many of them. I have great respect for Justice Leventhal, but I think that's plainly wrong. The statute requires that if you're entitled to summary judgment, it's only because you have submitted evidentiary material entitling you to judgment as a matter of law. And until those deposition transcripts were either sworn or the proof under CPLR 3116 was provided, they're not evidentiary and they can't be a basis for summary judgment. So no burden ever was imposed upon the plaintiff here to respond to the motion for summary judgment. So that's the first basis, and it goes to the entire motion for summary judgment. The second issue is that Justice Sherwood respectfully got it wrong here. The defendant didn't breach, or the claim is not that the defendant breached the representations and warranties. The defendant breached the contract. It didn't deliver what it was required to deliver in accordance with the terms of the contract. The time limitation that Justice Sherwood relied on in granting summary judgment applies only to breaches of representations and warranties. The plaintiff, or the defendant, contracted to deliver title to 5 properties, deeds to 5 properties promptly, and contracted to deliver a $200,000 mortgage on a property in New Jersey. It didn't deliver the deeds promptly. It took 6 months to deliver all of the 5 deeds that the contract required it to deliver. And there never was a $200,000 mortgage on the property. There was a $185,000 mortgage, which it finally delivered after proceedings in New Jersey courts. So they never performed. It's not a question of warranties or representations. It's a question of performance. The New Jersey proceeding, the defendant relied largely on the assertion that the plaintiff's participation in the New Jersey proceeding should judicially stop the plaintiff from pursuing its breach of contract claim here. But the plaintiff never argued, nobody argued in the New Jersey proceeding that the defendant had performed its obligations under this contract.
No, counsel, this is Judge Scarpula. The question was not, the question is, you're taking the position that they didn't pass good title, they didn't have title in this action. And the fact is, in the New Jersey action, you took the exact opposite position. And that is what you argued in New Jersey. That's what got you the conforming deed that you were looking for there. So now you can't come back to New York and say, oops, I got the deed, I got it late, therefore, or I didn't get what I thought I was going to get. But they never had it. You can't take those inconsistent positions. It's not that you're trying to put too fine a point on it.
Well, respectfully, Your Honor, the contract at its most simple here, the contract says they purchased a $200,000 mortgage. What they ultimately got was a $185,000 mortgage.
And there's also a representation, you get what you get. And it's on you to look at the documents, to look at the loan file, and to look at everything that there is to see what there is. And I mean, I don't see how you can argue that here. It's not on them, it's on you. It's on you to do your due diligence. And if the mortgage turns out to be a different number, you could have opened up the mortgage file. And if you didn't have it, you should have asked for it, or you should have, that is exactly the point of selling these mortgages, many of which who don't have good loan files, and that's acknowledged all over the agreement.
Well, but respectfully, Your Honor, if I buy an apple and get an orange, there's been a breach of the contract.
No. If you buy an apple and you didn't look and make sure that it's an apple, it's on you, and the contract says, you get what you get. I don't know if it's an apple or an orange. Here's the documents. You get what you get. You get what you get. And if it turns out to be an orange, that's on you, not on the seller.
Well, respectfully, Your Honor, I disagree. This contract specifically said they get a $200,000 mortgage, and they got a $185,000 mortgage. That's a breach.
Thank you. I'll let you, you have some rebuttal.
Okay, thank you, Your Honor.
Mr. Salter, I believe.
Yes, Your Honor, may it please the court. Counsel had three issues. I can address all three of them. As far as the prima facie case, the evidence was admissible the entire time. Counsel, his colleague, was served along with the witnesses of the CPLR notices, which the 60-day passed. As with most evidentiary objections, you put it in. If counsel raises an evidentiary objection, you say why it's admissible. If they don't, then they waived it and it's admissible. So the issue of prima facie case, I mean, we're not going to guess their evidentiary objections and address them in advance. The deposition transcript.
Although, counsel, this is Judge Scarpullo. Wouldn't it have been better to just put it in the first place? I mean, you may cure it on reply, but let's be real. You should have put it in the first place.
Your Honor,
if you had it, you should have put it in.
Your Honor, yes. And it's one of those things where you serve counsel with it. They know that the 60 days passed. I mean, when I receive it, I pass it along to my client. So it's you just don't expect someone to, when they have the file there, seeing that it was served and 60 days passed, to then raise it. So yes, Your Honor, it would have been much easier. We would have avoided this issue on appeal, but we get to the same place because we did comply with the statute, and the case law says, as you do with evidentiary objections or summary judgment, you put in your admissible evidence. They say, we don't think it's admissible. And on reply, you say it's admissible. We never put in new evidence. We just showed why it's admissible. So that's just the case law speaks for itself. The admissibility evidence is there, was always there. As far as the breach claims go, all the claims were dismissed on multiple grounds. And with the deeds, the entire premise of their brief and their position is they kind of want the law to not be what it is. Because if the law says that the properties are transferred when the deeds are delivered, which is what the law says, then they don't have a case, because there's nothing in that contract which says you need to give us all of the ancillary documents. As the lower court pointed out, we agreed to work on the ancillary documents together. So their idea that these properties were not transferred until the deeds were recorded is incorrect as a matter of law. And once that fails, they don't have a claim. So they just ignore that and they say, well, the recording, well, this and that. Well, it's, there really was no issue of fact here, because we all agreed these were the days the deeds were recorded. So everything was an issue of law. And as a matter of law, the deeds were delivered. They were the owners of the property regardless of when they were recorded. And if you go to the contract, which I looked at their briefs, I looked at their replies, not very many citations to the record, because nothing in the record says that they had a contractual duty to also give all of the ancillary documents and make sure those ancillary documents were accepted by the county clerk and go back and forth. They take issues with some of the, they make a statement about the incomplete emails or the incomplete deposition transcripts. They have the same emails. Discovery was complete. A note of issue was filed. If there was something in the emails or something in the deposition that showed any type of intentional, any type of misrepresentations, they could have and should have put it into the record, but they couldn't because it wasn't in the record.
Any other questions from the panel? No. Okay, thank you very much. Mr. Spolzino?
2 points, Your Honor. First, the contract required that the deeds be delivered promptly, regardless of when they had quote unquote title. They weren't delivered promptly. That's not a question that can be disposed of on summary judgment, number one. Number two, as far as the making out of a prima facie case is concerned, if the defendant had submitted an unsigned affidavit, and that was its only proof on the motion for summary judgment, should the motion have been granted? I don't think so. This is functionally the same thing. The burden is on the moving party to establish its entitlement to judgment as a matter of law on the basis of evidence, documents, or other evidence in evidentiary form. They
Counsel,
didn't do that.
let me just interrupt you. Haven't we moved past that? Haven't we moved past that? I'm gonna deny this motion because of something like that. Instead, we've gotten to the point where we say, can you fix it on reply? If so, let's not waste everybody's time by having a motion to renew with the same exact information, but maybe it's signed this. I mean, people make errors. There's no doubt about it. And we and the trial court have the right to ignore those errors as long as they don't involve a substantial right. So if it's cured on reply, why would we not just hear the merits of the motion?
Because, Your Honor, the plaintiff or the moving party has a burden. And until the moving, if the...
I get it, but if we look at the whole thing altogether, what I'm saying to you is we've moved past form over substance over form. We've moved past that in the law. We can't waste our time making the plaintiff, if they can't cure it on reply and no one is harmed by it, you haven't said in any way you were prejudiced by it, that we should deny the motion on that technical ground, make them make a motion to renew or re-argue, put in the thing that they actually did put in on reply. I just don't see how that makes any sense. So I'm okay.
Okay. I understand your position, Justice Scarpula. I think that there's a burden here and they didn't meet it. And the court has to abide by the law about what that burden is.
Thank you.
Thank you.
Katerina versus NYC Department of Buildings.
Good afternoon, Your Honors. Are you able to hear me now?
Yes.
Okay, I apologize for the technical issue that I had prior to that.
There's some things not within our control.
Thank
Go
you.
ahead.
Thank you for your understanding, Your Honor. Your Honor, my name is Peter Sayer. If it may please the court, I am the attorney for the appellant in this matter. Your Honors, the appellant, he commenced a proceeding under Article 78, specifically under 7803 subdivision 4 and 7804 subdivision G, to contest a decision from the Office of Administrative Trials and Hearings, oath, which decision ultimately revoked the filing privileges of my client so that my client could no longer file any more documents with the Department of Buildings, which obviously goes to his livelihood. Your Honor, it is our position that the oath decision and as well the subsequent adoption of this decision by the DOB commissioner was unsupported by the substantial evidence that was adduced at the trial. Even if it was not, even if Your Honors respectfully disagree with me, still nonetheless, it is our position that the penalty of revocation is grossly disproportionate to any offense for which he may have committed. Your Honor.
Counsel, so this is substantial evidence. That's not a very high burden to meet. And the agency, the Department of Buildings, has demonstrated that there were differences in the plans where it stated that things were recreation. They interpreted them as bedrooms. Where floor plans were, seemed to be similar to a floor plan where there were bedrooms, lots of things left out. If they found that, and if it wasn't unreasonable to find that, those are issues that are important safety issues for the public. When we're talking about basement apartments, why wouldn't it be reasonable for them to have taken the license away? This wasn't just one instance. These were multiple instances that they have.
Yes, Your Honor. I appreciate the question, Your Honor. Specifically, there were 9 construction jobs at issue for which my client filed applications on, 8 of which specifically to what you were referring to, whereby my client put recreation rooms in the cellars. However, Your Honor, it's our position that the administrative law judge, as well as the Department of Buildings, what they did not take into consideration were specific Department of Buildings documentation. Specifically, Your Honors, there's a DOB Bulletin 2012-008, and if I just may quote from it really briefly, where a cellar is connected and used solely by an individual dwelling unit for non-dwelling purposes, such cellar may be considered accessory to the residential use. I believe, Your Honor, that this must be read in tandem with another Department of Buildings document, DOB Memorandum 2000.
Counsel, this is Judge Scarpula. Weren't there 2 experts that the DOB had testified that disagreed with your view? And what's wrong with the oath officer accepting their testimony? Right?
Your Honor,
this isn't. They had two experts said, that's not right. And why should we disturb the oath officer's credibility determinations?
Your Honor, I appreciate the question. There were 2 experts who did testify on behalf of the Department of Buildings. We countered that at the oath trial with the testimony of our own expert, who used to be an employee at the Department of Buildings as well, and who was acknowledged as an expert in Department of Buildings filings, who also acknowledged the import and the significance of the Department of Buildings documents upon which our client relied in filing recreation rooms in cellars and properly labeling them as an alteration type 2. Because they were accessory to the apartment, there was no need to file them as an alteration type 1, as the use and occupancy of the apartments did not change at all. And again, they were authorized.
But counsel, my only point to you is that there was plenty of evidence in the record from the 2 experts upon which the ALJ could have ruled against your client. So where is there not substantial evidence? We all agree that there were 2 experts on one side, 1 expert on the other, testimony. The ALJ made credibility determination. So how is that not substantial evidence?
Because the substantial evidence, thank you for the question, Judge, Your Honor, the substantial evidence that was blatantly disregarded is the DOB documentation specifically.
Isn't it just a difference of opinion? 1 expert versus 2 experts versus 1 expert, and at that point, the administrative judge has to make findings based on credibility, based on the testimony. So isn't it fair then at that point that they are relying on the testimony and it weighs more in favor, they feel, of the 2 experts that represented the Department of Buildings? Well, isn't that a fair and an adequate basis?
Your Honor, it is a difference in opinion. And as a matter of fact, I know that
substantial evidence is why I started off saying it's not an easy, you have a high mountain to climb.
I am aware, Your Honor. You're right. You're 100% correct. Part of the record that we had prepared in our Article 78 petition was the entire transcript. And there's a colloquy at one point in which the respondent, who is here the petitioner, the appellant, asks one of the DOB witnesses, doesn't this boil down to a difference of opinion when we're all experts here on the building code, on the zoning resolution, on the multiple dwelling law? And is it not possible that we may have a different interpretation than you would have a different interpretation? To which they actually answered, yes, it is possible. But Your Honor, I would suggest that because we also put forth an expert Mr. Winter, who is as knowledgeable about the building code and the Department of Buildings regulations as the experts who testified at the oath trial. His opinion doesn't matter any less than that was offered by the DOB witnesses. But like I said, on top of it, we also have directives from the Department of Buildings which actually permit recreation rooms in the cellars of apartments. And these two documents, again,
I don't disagree with you about your directives. I think what it is that the findings were that these were not recreation rooms, that they were bedrooms.
Well, Your Honor, to that I have
misnamed as recreation rooms, which was, I think, precisely the problem that the administrative judge had here. Anyway, let's move on. You have rebuttal. Ms. Steiner.
Good afternoon, Your Honors. Julie Steiner for the DOB. As you are aware, Your Honors, this case has extremely long and very fact-specific. So to avoid a tedious repetition of that, I will suffice it to summarize that the key theme in this case is the petitioner's repeated pattern of deception in his repeated filings with the DOB that misrepresented and dangerously misrepresented at that rooms, egress points, and other matters that made it dangerous for people to live in it and put the health and safety at risk. And in doing so, he exploited DOB's limited review program, which was designed for trustworthy individuals, and he showed that he could not be trusted. The substantial evidence in this case, Your Honors, came out of the DOB's 3 witnesses, 2 of which were registered architects, and 1 was a structural engineer for the DOB. The other 2 were also his auditors. And many of the evidence showed
what about what counsel says about there being DOB documents that say this is permitted? Why don't you focus on that?
So, as Your Honor pointed out, the ALJ did not find, based upon the testimony of the DOB witnesses, that their interpretation of these documents were credible or accurate. And indeed, these 2 documents do not bear on the decision here. The 2012 memo that they are referring to only discusses what is considered an accessory space. It does not go into a discussion of recreation rooms. The 2003 memo, which they highly rely on, particularly in their reply brief, that while that does talk about the requirements for recreation rooms, it's not applicable where there were, like, I think 8 protocols that he had to meet, and he admitted that he did not satisfy those protocols, in addition to which the recreation rooms that he claimed he made were in fact bedrooms based upon the credible testimony of the DOB's witnesses that described them as having to be, the bedrooms had to be enclosed with, the recreation room had to be unenclosed, no partitions, and a very tiny bathroom, which is what this 2003 memo actually describes. So he had knowledge or notice of what in fact a recreation room was, and by his mislabeling them as recreation rooms when in fact they were enclosed with larger bathrooms, he therefore was able to not have to have the required dual egress points, which makes it extremely dangerous for someone to live down there if in fact they are living in one of those bedrooms as opposed to a rec room. So none of these DOB documents had any bearing on the decision. They were not applicable here, Your Honor.
Thank you. Mr. Sayer, you have a minute.
Thank you, Your Honor. To begin, just to address the mislabeling, yes, my client did mislabel certain rooms. However, my client also promptly took steps to rectify any further construction with regard to the mislabeling, which his expert, who was deemed an expert by the ALJ, deemed to be sufficient. He had written letters to the project manager. So I'd like to and at the same time, Your Honor, I'd also like to simply point out that the DOB has in the past accepted alteration type 2 applications for recreation rooms in the cellar, and this is something which our client
recreation rooms with bathrooms, and I don't know if this one had a closet or whatever that just so happened to equal the footprint of the apartment above. Those kind of recreation rooms where multiple instances are done, not one mistake. multiple?
Your Honor, it was an error for the ALJ to not allow to not allow the petitioner to even enter these applications into evidence, even though the DOB attorney at the time consented to their admission into evidence. But at the same time, Your Honor—
Counsel, this is Justice Kennedy. So you're talking about error, but you wanted to put that report in to impeach a witness's testimony. What evidence was there that the particular witness had any role in the approval?
Of those, Your Honor, just to be clear, of those specific applications that we wanted additionally thrown into evidence?
Right.
Oh, no, the point of our client putting them into evidence, Your Honor, was simply to show that the DOB has a precedent of accepting alteration type 2 applications for recreation rooms in the cellar, but yet for these particular instances is choosing not to do so. Instead, what it's choosing to rely on is when they say, well, and I quote, "we consider a rec room." But this is not based on any code, regulation, or statute. It's simply what they consider it to be based on. They don't proffer any authority for their definition of a rec room. And our client, who also has 40 years of experience as a professional engineer, has also testified, and I would say credibly, Your Honors, that a recreation room can have partitions, and that's not foreign to a recreation room. There's no countenance for the DOB's interpretation of what a rec room is.
Thank you. Thank you both.
Thank you, Your Honors.
Martinez versus Patel.
I guess the appellant is not here, Your Honor.
I don't know. Mr. Russo? He's supposed to be here. He never
signed in.
He never signed in.
No,
Okay.
they're doing the whole
Well-
thing. Should I go ahead, Judge?
Yes, so it's just you and Ms. Mottola. Ms. Mottola, did you file a brief in this case and request time?
Yes, I did.
Okay, Mr. DeJoseph, why don't you begin?
I'll be brief, Your Honor. This case, there are numerous questions. And good afternoon, Arnold DeJoseph for the plaintiff respondents, I'm sorry. In this case, there are multiple questions of fact regarding the conduct of the defendant yellow school bus in this case. First of all, it's a mechanical breakdown, and yet somehow the defendants believe that they don't have to supply maintenance records and that no inference will be drawn from that, and we're to rely solely on their testimony that there was nothing wrong with the bus before that. But the statutes require them to maintain these records. They should have, to establish their prima facie case that they didn't have any notice of a mechanical defect, they were required to put these records in and show that. They didn't do that. The bus operator, the truck shuts off in the right lane on the Bronx River Parkway. Now, the plaintiff, the only testimony as to his speed at the time is that he's going at least approximately 20 miles an hour. The speed limit on the Bronx River Parkway, as a matter of law, we know is faster than that. Yet somehow he's not able to get the bus onto the shoulder of the roadway.
Well, Mr. DeJoseph, he said that the engine stopped, and so that the steering, he couldn't move it. He doesn't disagree with the plaintiff that the bus was rolling. He says, yeah, okay, the bus was rolling, but the engine stopped and I could not move the steering wheel. Did you present an expert who was able to talk about what kind of bus it was and whether or not there would be any issue with regard to this, the steering? Because otherwise I don't see where the question of fact is.
Well, Judge, he didn't say, how did the bus come to a, is he saying I couldn't? Look, I understand that when, and this is common knowledge, you don't need an expert to understand.
Oh, I don't know about that. Different, Judge, not common knowledge to me.
Judge, let me explain what I'm saying.
Okay, but don't talk over me, Mr. DeJoseph, please.
I'm sorry, Judge?
Don't speak over me.
No, I didn't mean to, Judge.
I know.
One of the things, Judge, is your picture's not up, so.
My picture's not up?
No, not on my.
Neither is yours, but I don't know. I think my picture is up. I think some people can see me and some can't.
Yes.
But I have noticed we can't see you. Did you think your picture was up?
I see myself.
Well, there's a problem with the, there's a technical issue because I've noticed that there were a few attorneys arguing whose pictures we could not see. So unfortunately.
Judge, I only mention that to you because I can't see that you're starting to speak.
I
Otherwise, I'd
understand.
shut up. Okay. But getting back to what I was saying, Judge. So let's move on to the, if that's okay, I'll move off that. Let's get to the next issue. The bus breaks down in the right lane on the parkway. There are requirements. There's guidelines on how you're to set your markers behind the bus, your reflectors. This bus driver only says, he admits it. I only put 2 down and they were 10 feet behind the bus. Well, the guidelines say you put it 100 feet behind the bus. And it's critical here because if you read the testimony of the defendant, he says, I see the bus more than 100 feet ahead of me and I can't tell whether it's stopped or not. But
yes,
if they have
okay, he is the driver who hits in the rear. And we have a lot of cases that say you hit in the rear, that you're liable. And his reason for saying that no, there's contributory negligence here is that the triangles were placed underneath the bus. Now, I've heard a lot of things, but I don't know why anyone would put their blinkers on and go out and risk their lives in traffic and then place triangles under a bus.
Judge,
it just seemed like a feigned issues or something to me.
Well, but no, we're missing the point. It's not a feigned issue that the bus driver admits that he did not place the reflector where it was supposed to be.
You're right. You are
Behind
correct. He did, from what you're saying, I didn't read that, but from what you're saying, he didn't place it where he was supposed to, but that is not what the plaintiff said. The plaintiff said, I'm sorry, not the plaintiff, the defendant driver who hit the bus. What he says was it was under the bus, which is completely inconsistent with what you are saying now.
No, not inconsistent, because I'm not under the bus or 10 feet behind the bus isn't the problem. The problem is not placing it 100 feet behind the bus, because once you don't place it 100 feet behind the bus, you now are limited to that reflector being 10 feet in front of behind the bus. Let's assume we accept the defendant's testimony on this, that it was 10 feet behind the bus. Well, the guideline says 100 feet. The defendant driver that struck the bus in the rear says, I saw this bus more than 100 feet in front of me, but I couldn't tell whether it was stopped or not. That right there creates the question of fact as to whether if that reflector had been properly placed 100 feet behind the bus, he would have realized that this bus had a mechanical problem or was disabled in the right lane, and given him time, which at the speed he was traveling, 40 miles an hour, he would have had at least 2 seconds to get out of the way or stop himself.
I wonder, since he thinks they were underneath the bus the entire time. In any case, let's move on to Ms. Mottola.
Well, okay, Judge. Okay.
Thank you.
May it please the court, my name is Susan Mottola and I represent the defendant Patel. I'd like to adopt counsel's arguments, but I would also like to add that defendant Patel testified that when he saw the bus, he didn't see the stop sign jutting out. He didn't see any emergency lights. And so there's an issue of fact as to the
he didn't see anything, even though the plaintiff, who has every reason to be truthful when it comes to the bus driver, because she brought an action against him, says the bus driver got out and the bus driver put on the blinkers for the bus. So interesting, but.
With the summary judgment motion, we have to take the opposing party's testimony as true. It should be considered as true. So this raises a tribal issue of fact as to the comparative negligence of the other driver, the bus driver.
Do you have anything else?
No, I don't.
Okay, thank you both.
Thank you. Have a good day.
You too. Board of Managers, Porterhouse versus Delshaw 60.
Joseph Cambereri for the appellant and the respondent on the cross appeal. Your Honors, the court below should have dismissed the cross claims by the Delshaw defendants that are couched as professional negligence or called professional negligence claims, because D'Aronzo moved to dismiss all claims for contribution. And in moving to dismiss all claims for contribution, that necessarily encompassed a claim for or cross claim for professional negligence. There's nothing magical about calling a claim a professional negligence claim that makes it something other than a contribution claim. The claim that Delshaw couches as a professional negligence claim is based on the very pleadings that you'll see at page 72 of the record. Part of that cause of action, it pleads professional negligence for any liability that Delshaw may have to the plaintiff for breach of contract. It specifically says, it pleads that the plaintiff has pled breach of contract against Delshaw, and Delshaw's seeking a claim over against D'Aronzo for professional negligence.
Did Delshaw delegate any of its responsibilities for renovating and doing the work to Blue Arch and D'Aronzo?
Your Honor, they did not delegate anything. They hired D'Aronzo to provide design services. They did not, Delshaw did not contract with the neighboring landowner for Delshaw to do some project for the neighboring landowner, and then Delshaw in turn delegated that to my client. Delshaw just merely hired my client to design some renovations to the building, and based on a separate agreement that runs with the land, a zoning land development agreement that the predecessors of both Delshaw and the predecessors of the neighboring landowner had, based on that contractual agreement, and a breach of that, which had nothing to do with, what we were hired for, based on that, they're bringing this claim over. And just to point out, the court below also erred because it noted that only in D'Aronzo's reply did it raise issues about professional negligence. That completely disregards the fact that Delshaw made a separate cross motion, which is being appealed today also, a separate cross motion to convert those cross claims to third-party claims. And in opposition to that cross motion, D'Aronzo specifically made the same arguments that these professional negligence claims were nothing more than claims over for contribution. Now, I would point out, Delshaw specifically notes in its brief at page 21 of its respondent's brief that, and I quote, Delshaw does not seek an equitable allocation of tort liability against a joint tortfeasor. Also, the court's order specifically found that Delshaw does not oppose the dismissal of contribution claims. So with that, in trying to do a end around and calling this claim a professional negligence claim when it's really just a claim over based on negligence that seeks apportionment, that's part and parcel of what was moved for dismissal and what was opposed by D'Aronzo. Now, with respect to the other finding of the court that there is a nuisance claim based on excessive noise being made by the plaintiff against Delshaw for rooftop HVAC equipment. The court below found that a common law indemnity claim could survive, not that it had merit, could survive against the architect who designed the roof. As a matter of law, Your Honor, that was incorrect. There is no case law to support the proposition that a party that's creating excessive noise on its property and is sued for nuisance for that excessive noise, which is a cause of action that is the character of that cause of action is a continuing wrong for repeated conduct. So
any questions? Oh, sorry. Finish it.
That's all right, Your Honor. So the point of that is there is no conceivable necessarily, if Delshaw is found liable for negligence for creating excessive noise on its property, there is, as a matter of law, that cannot be 100% attributable to an architect who designed the roof.
Thank you. Any questions from the bench? Okay. Mr. Carbone?
Yes, may it please the court. Your honors, are you able to see me? Are you getting my?
Yes.
Okay, great. We had a little bit of technical issue. I want to just start with something.
I think we all are today.
I want to just start with something that Mr. Cambereri said about the relationship between contribution claims and professional negligence claims. He used the term that a contribution claim necessarily encompasses a professional negligence claim. That is utterly false. Contribution has a very specific doctrine in the law whereby two parties that have no legal relationship that are joint tortfeasors can allocate the liability between those parties, notwithstanding the fact that there's no legal relationship between them. That's not the case here. We have an instance where my client, Delshaw 69th, is a property owner. It hired Mr. Dioranzo as its architect. Mr. Dioranzo supplied architectural services to my client. There is a legal relationship there that establishes a standard of care and a duty by Mr. Dioranzo with respect to the services that he rendered. The reason that Mr. Cambereri is making this argument is because of the court's denial of the branch of his motion targeted towards the professional negligence claim on the basis that it was first raised in reply. There is a third department case called Temp Force versus Municipal Housing Authority. In that case, there is a property owner, just like there is in this case. That property owner hires two different consultants. It hires an architect and it hires a construction manager. The construction manager ultimately incurs liability to the to the property owner in contract. The construction manager then tries to shift that liability over to the architect, even though it has no legal relationship to that architect. Its contract is with the property owner. The architect's contract is with the property owner. The court sees through that attempt to do an end around the contribution rules and says, even though you've styled this case as professional negligence, we see what you're trying to do. This is an improper contribution claim. That case does not stand for the fact that contribution and professional negligence are the same things. And so it's important to carefully analyze the facts of that case that Mr. Dioranzo is relying upon, because it's factually completely distinguishable. In this case, we have an architect that supplied services directly to my client. That's conceded by Mr. Dioranzo. He's not disputing that he supplied services to my client as an architect. That was not the case in Temp Force. The architect did not supply services to the construction manager, even though the construction manager was trying to pursue a claim to shift his contract liability over to them. One thing that I will say is,
why don't you have a minute? So why don't we go to Mr. Cambereri?
Sure. Okay. Thank you, Your Honor. I'm going to point out very clearly why that professional negligence claim has to be a claim for contribution. Contribution is a right. It's a right to seek apportionment. It's not a cause of action. You need a basis such as negligence to assert contribution. You can't just say contribution and that's your cause of action. Contribution is the type of right that you're granted by statute. Negligence is what brings you into that. So the fact of the matter is, all of the claims against my client are claims over. They can only be, they're not for separate damages. There's no separate damages. We call it Delshaw. They're only seeking recovery if they lose to the plaintiff. Those claims have to be either contribution, contractual indemnity, or common law indemnity. They're not contractual because there's no contract and that was dismissed. They're not common law indemnity because the court completely dismissed common law indemnity already in its order. It's not a vicarious situation. So it has to be contribution. It can't be some other amorphous professional negligence that's not for separate damages, but we're also seeking recovery for whatever we might lose to the plaintiff.
Sir, I'm sorry. This is Judge Shulman.
Yes, sir.
I'm responding to your point that there can't be common law indemnification. There can be, based on our case law, if in this case Delshaw completely delegated through the contract with your client, the architect, take care of the situation, this project. You work with Titan Construction and do what you need to do to get it done. And somehow in that context, by totally turning it over to to a professional, to the architect, to this expert, to take care of this, that our case law does permit common law indemnification that is, I think, my word, akin to vicarious liability. And that could be the basis. And we also know you can have professional negligence that's in the context of a breach of contract and not necessarily negligence in the context of tort. So let's put contribution aside and just stay focused on the fact that they are seeking common law. And that is the basis of their cross appeal to reinstate that claim, if I'm not mistaken. Am I correct?
Your Honor, let me respond to that. The fact of the matter is, by their very own pleadings, they did not delegate 100% of responsibility to my client. When you delegate responsibility, you delegate it to one person. You don't delegate it to 12 and then say, I have a right to common law indemnification. We didn't build the structure that encroaches on the Zelda. The contractor did. We were just doing designs for the building. So how were we delegated 100% responsibility when they say, they even say in their papers that Delshad delegated responsibility to either Titan or to D'Oranzo, and then somewhere else they say they delegated construction to Titan, and then they delegated full, respect. And the other point is, you can't delegate responsibility for an easement that runs with the land. How did they delegate 100% responsibility to my client not to violate an easement that was in place between two predecessor owners of the property? This is a Zelda agreement which runs with the land. How does my client, an architect, now have full responsibility as an insurer that now, if there's an easement that runs with the land, only I can be responsible, not the owner who owns the property, who is a party under that agreement? They can't delegate. We have to remember.
Thank you. I think we have your point. Mr. Carbone.
Your Honors, as a corollary to Justice Schulman's point, the case of this court, 17 Vista Fee Associates versus Teachers Insurance, is a veritable roadmap for almost every legal issue before us today. And that opinion was written by Justice Mazzarelli, who joined us at the top of the calendar. It is a thorough, comprehensive analysis of common law indemnification in the context of a construction project, as well as the fact that a professional negligence claim can coexist with a common law indemnification claim in this type of situation. And Mr. Cambereri's points about you cannot delegate this, that, or the other thing to an architect, that's proven false by the 17 Vista Fee Associates case, where the court determined that the architect inherited a responsibility to design to a particular standard, and if that standard wasn't met, the architect was liable in both professional negligence and common law indemnification. That is the exact same circumstance we have here. We have a Zelda that was provided to the architect, and the architect was asked to design within the constraints of that Zelda, a zoning lot development agreement. It's no different than saying, you have to design this building to make sure it's not on our neighbor's property or something like that. It's part of the architect's standard of care. It's frankly not something that we can resolve at the pleading stage. It's a question of fact. And we've pleaded that we relied upon Mr. D'Oranzo Services to design the building in accordance with the constraints of the Zelda, and he breached that. And that is.
May I make a very quick point?
No, I'm sorry. Thank you both. Thank you both.
Thank you. Thank you.
This is the last case for the calendar today, and that concludes our oral arguments. Thank you both.
Thank you, Your Honor.
Thank you. I didn't get to say this whole point. When she said 17 Vista case, I had my whole point there. They didn't let me talk.
Dad, you did great. She didn't make a ruling or anything.
No.
So what was the point if there was no ruling?
I can't believe it. Sophia, why are you saying this?